make some adjustments.
May I please, Your Lordship? I beg to mention item number 30, Your Lordship. With the consent of the other side, kindly adjourn the matter for the day, Your Lordship.
You're for?
I'm from Caveator, Your Lordship. I'm appearing for Mr. Vijay Mukherjee.
With the consent of the other side, Miss
Yes, Paul.
Yes.
Paul.
Paul learned counsel for the respondent gave it a place for adjournment. Here is allowed. List. Give it date next week. This
May it please your lordship. Lordship, I beg to mention item number 21, my lord, from today's daily list. With the consent from the other side, my lord. This matter may be adjourned for today, my lord. Item number 21.
You're
And
for the
one more thing, my
you're
lord.
for the petitioner.
Yes, my lord. We have filed one affidavit, my lord. That is also not on record, my lord. So the matter may be fixed on 29th, my lord.
Consent of the other side, learned counsel for the petitioner place for adjournment. It is submitted that the affidavit in opposition has been filed by the respondent, which is not on the clock. The issue shall tag the said affidavit on the clock. List on 29/5/2026.
File you, Bilashman.
Right. My lord, as regards item number 36 of daily list, my lord, this matter has been remanded by the Supreme Court for fresh hearing. That during the pendency of the SLP before the Supreme Court, the respondent number 2 had died, and it was legal heirs of respondent number 2 has been substituted. But here in this second appeal, they have not been substituted. I need 2 weeks more time because it pertains to Sribhumi district. I have sent the application, but it has not been reached to us.
You're taking consent of.
I have taken consent from the other side.
Books as a representative. In the SLP, it has been substituted.
My lord?
In the SLP, it has been substituted.
Yes.
Mr. A. Dhar, learned counsel for the appellant has submitted that the matter is remanded for a fresh hearing by the Supreme Court of India, and during the pendency of the SLP, the respondent number 2 had expired and was substituted. So, however, formal application for substitution has not been filed in this matter. So accordingly, the place one is granted 2 weeks time to do the needful. Give a date after 2 weeks. Okay.
Yes, may I please, lordship, I need to review the item number 14, lordship. Motion matter, lordship. May I some accommodation, can I be fixed next week, lordship? I have to enter some instruction regarding the previous status, lordship.
14.
Yes, lordship.
Just after a week, I paid for by learning counsel for the petition.
Okay.
May I please, Lord. I beg to mention item 20, Your Honor. May I pray for fix on day after tomorrow? Tuesday. Lordship directed us to find out whether it would be revision or appeal.
You're taking consent of the other side.
I have taken consent.
You're for the respondent.
Lordship.
Consent of the other side, learning counsel for the petitioner, place for adjournment, who is allowed. List on. Want to do it on Friday.
Right.
22/5/2026.
May I please, Your Lordship, I beg to mention item number 9. Lordship, matter may be adjourned for a week because some instruction is required for my client.
This after week is paid for by land council for the petitioner. Yes,
My lord, I beg to mention item number 35, my lord. 2010 matter. In this case, my lord, in the month of December, I have filed application for substitution, abatement and setting aside of abatement, my lord. But it has not been come, my lord, on record. So may I pray that it may come up on Friday, my lord. In the meantime, I'll check up whether there is any defect in the IA or not.
anything problem with the offer? I will be sure Monday, 25th.
Monday. And item
You're
20,
taking consent of the other side?
yes, I have informed.
Consent of the other side. Mr. S.K. Ghosh, on counsel for the applicant. Place for adjournment. This will be submitted that on
On 18th of December 2025.
18/12/2025. Application for substitution, setting aside the abatement and continuing the delay
3 IF.
on account of death of
Death of defendant number, respondent number 1.
respondent one has been filed, is not on record. He pays for some time to find out as to whether there is any defect. Accordingly, matters since adjourned today. In the event the interrogatory applications are filed and are not with any defect, how much the issue shall use those interrogatory applications or be made clear on this too. Next, in the meantime, the applicant should also find out as to whether there are defects in the filing and rectify the same in the course of the day. Within 2 days, based on 25/5/26.
My lord, in item 20, that had mentioned, there is an interim order, my lord.
Item
20.
20 is been adjourned, okay. This is an interim order.
Yes, it was on.
Interim order passed released and is extended in item 20.
I beg your pardon, your lordship. In item 21, there is an interim order, my lord, operating now. That may be.
21. Okay.
I am appearing for the respondent in item number 21. My appearance may be recorded.
You said what size are represented? Okay. Interim order extended. Okay.
I am deeply obliged. May please, okay. But may kindly allow me to peruse the reports of item number 37.
Your Honor, I'd like to mention item number 55, supplementary list. On behalf of the petitioner, Counsel E.K. Pukashta. 55, it's for orders.
Why it has come for orders?
The subject matter is known to my senior lordship. He is, letter of absence has been given for the past 18 and 19. He is unwell. So today he is kept unwell. So.
On the ground that the counsel for the applicant is unwell, here for his journal this will be. Who's appealing for respondent? You are taking consent of respondent number 1 and 2?
They are confirmed with my senior. I'll confirm. Not he has not.
No, not without knowing. Please confirm it because without ex parte adjournment will not grant.
Right. Maybe the lordship. I beg to mention item number 26. There is some difficulty on the part of the conducting consumer. It may be taken up after 2 weeks.
26. When you inform the other side?
I have.
You're for the petitioner?
I'm for the petitioner.
Consent of the other side. You then counsel for the petitioner, please for adjournment. There is a law. Please talk to 3 weeks. Yes.
May please,
There is an interim order.
Then why you are taking an adjournment for 2 weeks?
There is some.
Then Monday.
No, at least 1 week.
You see, there must be some reason to have an interim order and then take an adjournment.
I have,
What is the
provided-
reason?
I have already,
It's been, proceedings has been stayed. And no, Monday, 25th.
25th some difficulty, Wednesday. On Wednesday.
Wednesday is a holiday.
Oh, on Thursday morning. Thursday morning.
Make it 29th. Yes,
Obliged.
May it please proceed.
the interim order passed to the stand yesterday. Yes,
I beg to mention item number 51, Lordship. R51. Also date may be given as a learned counsel is out of station. Also, I have taken the consent from the other party.
there's so many IAs. What are these for?
Lordship, the learned counsel is mentioning that.
You are for whom?
Lordship, I am appearing on behalf of NS Majorbian.
Item 51. You're taking consent of the other side?
Yes, Lordship.
Consent of the other side, and counsel to the applicant pays for adjournment. As the corrected series of the year 2020, this is the matter on 25/5/2026.
Most obliged, Lordship.
Top of the list, item 1.
May it please the Lord. Lordship, in this matter, Lordship, service was evaluated method. Upon the respondent number 2, the IA 771/20. We the respondent Kishorilal put that expired method. Then we have taken steps upon the legal heirs of the deceased mother. And as per the order of the Lavajima Court, my lord, order dated 16/7/24. Service upon the respondent number 1 was completed, my lord.
But this is a different counsel to the applicant. Order dated 3/11/2025, steps was ordered to be taken again, on the respondents. On the substituted respondents by 17/9/2025. Service of notice of filing of the form of secretary responsible by registered post to the AD as per the UP. That's all. As per the office note dated 18/5/2026, the usual process has been served. As the substitute respondent number 2 has received notice on behalf of the respondent number 1 and for himself. Further, as per the order of the Lavazima Court dated 16/7/2024, notice on respondent number 1 is duly served. It's sent by registered post to speed court to the AD or duly served. According to the applicant, application is note that notice on the respondent is duly served. None appears on call for the applicants. What is the reason for 2600 days delay?
Malad, that I have said in para 3, Malad. Malad, that I have come to know after the steps that I have taken in the CRP, Malad. The respondent expired in the year 2012 itself, Malad. Although we could not trace out the names of the legal heirs, then we wrote a letter to the concerned of our office at Gwalpara, Malad. And this is the names that we have placed here, Malad, are the from the records that we have in our office.
The date of death,
Date of death, my lord, we'll find it in my IA 772, I think.
give me the date. Give me the date of death.
Yes. 29/9/2012, my lord.
The learned counsel for the applicant has submitted that the respondent number one in CRP 76 of 2015 had died on 29/9/2012, and though the execution proceedings being P X case number 1 of 2010 was proceeding, but the deceased respondent was not substituted. And therefore, agreed by the order dated 27/10/2014, passed by the learned District Judge Kumar Valpara of the petitioners had filed this revision petition under Article 227 of the Constitution of India. So, take it that in course of this, the proceedings of CRP 76 of 2015, notice issued on the full respondent therein was returned postal remark addressee expired, returned to sender. And accordingly, so how they said order of the Narasimha Court, dated 8/4/2016, came to the notice only on 31/10/2019. And thereafter, the application for substitution, setting aside the benefit and contention application were filed. '27 to 2020, And in the process, there was a delay of what is it, delay 26?
Lord,
What is it, delay 26?
2617.
17 days beyond the period of the mediation by the application for setting aside abatement. And application for substitution. In light of the projection that with the sole respondent in CRP 76 of 2015 had died in the on 29/9/2012. There was no substitution by the respondent in the execution petition filed by him. It was still order dated 27/10/2014 or filed. Court will consider opinion that the applicants have been made able to make out the case for following the ordinary delay of 2617 days beyond the period.
2617.
2617 days beyond the period when the sanitary application for setting aside abatement and certification. According to this, if you look at the application stands out. This will be in IN number 771. Second is 773. But this say it occurs in conflict with the applicant, none appears on call to the respondent. Respondent, although the notice is duly served. It's reflected in the quarter past today in ISO 771 of 2020. Next. This is an application under order 22 rule 9 of the CPC for setting aside abatement of CRP 76 of 2015 on account of death by the sole respondent in the connected CRP 76 of 2015. Next up. It is the same as the earlier but of the delay. He died on 2012. I don't know, it's the same article from here. Accordingly, comma, the Still opinion of the court. Applicant has been able to make out a case for allowing the application for setting aside abatement as the sole respondent in CRP 76 of 2015 did not have himself then the applicant in transfer was not substituted in the execution petition being EX case number according to this interpretive application stands about and the abatement on account of letter of response to the response of one in CRP 76 of 2015. Hereby set aside. Then 772. It will be same thing. This last paragraph will change. And we are working on as the respondent in CRP 76 of 2015 was not substituted in proceedings of TX case number so and so. And these details, strictly hold the applicant has been able to make out the case for allowing its substitution accordingly. Look at the application stands allowed. Then the CRP you say but in view of the orders passed in the connected IS 771 of 2020 or 772 of 2020 and 773 of 2020, the sole respondent in this revision is allowed to be substituted by his legal representative. Nature that there in the also the above. Please look at the applications. Next one, the non-counsel for the petitioner shall file an amended cost title of CRP of this division within 3 working days. So the same will be handed over to the AOJ. Civil revision section. Yeah. Civil revision section. Incorporate the same in the revision and update the CIS data. So instead of 771, this will be in modern 771 would be in 774. In 771, you say refer on the applicant. This is an application under Section 5 of the Mediation Act for following the delay in filing the application for substitution. As separate order has been passed in IS with 774 of 2015, plus which is an application for following delay in setting aside abatement. This interlocutory application is found unnecessary and therefore since stands closed. as said, I civil 774/2020 as it considered in the route. And it is CRP, you say. As an execution application of the year 2010 has been stayed, comma, on restoration of this, sorry, on substitution, comma, the petitioner shall take first step for service of notice on the respondent, the substituted respondent by equal to the The learning council for the steps shall be taken within 3 days. Next, learning council for the applicant is permitted to correct the postal receipt number and submit postal track report prior to the next date of the stay. Next, list the matter on usually after 4 weeks. Steps again on this, on the substitution
CRP.
allowed.
On the CRP one. On the
This CRP.
Moment.
Item 2.
May please, your lordship. My lord, in this case number ISC of 862 of 2020, my lord, in compliance with the order of the Honorable Court dated 17/7/2024.
You have not taken steps.
My lord, that is why I am a bit surprised because my learned friend says that he is appearing. And my
He is
lord, this
appearing.
is-
You are appearing for the respondent. For? For 3 and 4. And you are for?
And newly substituted lordship, I have not filed the wallet to A, B, and C lordship.
How will this application be maintainable?
My lord, legal errors of respond number 2, my lord.
But you are using the the provision of section 146 CPC.
My
It's
lord,
not an application for substitution within the meaning of order 22 rule 3.
I'm sorry, my lord.
You see, you have filed this application under 146 CPC. 146 is to continue the proceeding against somebody who is claiming under the party.
Order 22, rule 3 and 4 are not applicable in case of execution proceeding, my lord. That is why I resorted to section 146. My lord, order 22, rule 3 and 4. When defendant dies, my lord, rule 4 is attracted, my lord. But rule 12 says, application of order to proceedings. Nothing in rules 3, 4, and 8 shall apply to proceedings in execution of a DPO order. This revision petition has been preferred against an order passed by the learned executive court rejecting my application, which was filed under section 47 of the CPC. I, being aggrieved, preferred this instant revision petition, and during the revision petition, my lord, respondent number 2 died. So, my lord, as I am barred, my lord, to resort to rule 3 and 4 of order 22 CPC. In section 146, my lord, says that proceedings by or against representatives, save as otherwise provided by this code or by any law for the time being in force, where any proceeding may be taken or application made by or against any person, then the proceeding may be taken or the application may be made by or against any person claiming under him, my lord. That is why, my lord, this petition was filed under section 146.
Okay, yes,
Lordship.
what do you say?
Lordship, I have not received a copy. I have only oral instruction over telephonically
You could have
instruction.
requested, the execution cases are pending. You could have
Lordship.
requested, so that she would not have denied you that copy.
And for substitution, Lordship, I have no objection to substitute.
Yes, your stand? Please speak loudly, come here, speak loudly, I'm not hearing you.
I have not received the copy. I have not filed my wakalatnama. I've been instructed to file wakalatnama, but I'm for pro forma dependent.
Then this topic you give copies, we'll take it up Friday. Have this speech original counsel for the petitioner, sorry, applicant. Also had Mr. He had shown that counsel appearing for the substituted respondent. For the respondents, ought to be the respondent ones ought to be substituted. One two ought to be substituted. Also heard Miss A. Barwa, then counsel appearing for respondent number 3 and 4. Next. The counsel for the purposes of respondent. You will also appear for number 1 also.
Lordship, I am.
The young counsel for respondent number 1 and substituted. And opposite parties ought to be substituted for respondent number 2. Submit that he has been instructed to appear for the said respondent. However, if he has not received a copy of the application, the young counsel for respondent number 3 and 4 also please for a copy of this application. Counsel for the applicant shall provide copy of the application to appearing counsel for the respondents. Next slide. You filed your wakalatnama when?
File it today.
Okay. The history shall track the Wakalatama filed by counsel for respondent numbers 3 and 4. Stated to have been filed today on record, and reflect our name in the causes file listing will happen next paragraph. Copy of this application will be provided to the appealing counsel in the course of the day, list on 22/5/2026. Please give copy today. Correct it from her.
Item 3.
There is another revision, my lord, my lord, my lord, that is a 2011 of 25, my lord. 211 of 25. Well, there, my lord, they have obtained a stay also, my lord, execution of decree. My lord, what happened, my lord? Suit was filed, the original plan died. The substituted legal heirs, my lord, they contested the suit. One of the brothers, my lord, already settled in Jagirot. It's a case from Dhubri. And he has business at Jagirot and Gauhati. Now, my lord, after obtaining 6 months' time from the Honorable Court, they did not give any undertaking, and they brought him to sustain the degree, my lord. Supreme Court has taken strong action, my lord, against them, my lord. Put,
211 of 25.
my lord,
211 of 25.
200, so I pray, my lord, we both the matters taken up on Friday, my lord, I think it will be better, my lord.
Yes, no.
Very similar cases are there from Supreme Court, my lord.
CRP 2011 is on separate issue.
The name of respondent number 3 and 4 are being struck off. You have not taken steps. It's an execution petition of, which has been stayed of 2018.
Yes.
We are striking this out.
My lord, another matter is
The-
99 of 23.
And yes, I will, then nothing to suggest that. It's- I forgot your name.
My lord,
Your,
the other case.
no, the assisting counsel.
Oh,
Ms. K. Bhattacharya will counsel for the respondent, number 1. Next one.
please.
Notice that the respondent number 2 is reportedly expired and there's no application for substitution or respondent number 2 was received. It's this court order dated 25/3/2026. On submission made by the non counsel for the petitioner, their, his presence is not required. The name of respondent number 2 was struck off. Next. From the office dated 30/4/2026, and it is not that no steps was taken for service of notice on respondent number 3 and 4. Accordingly, as despite office note dated 30/11/2023, 19/8/2024. Twenty-one, 1/2025 and 7/10/2025. It's not been taken. And considering the fact that execution petition being TX of 2018 has been stated. The name of it, the respond numbers 3 and 4 are struck off. Next. The term council, senior counsel for the respondent has submitted that in connection with the same execution application from a CRP 211 of 2025 is also pending, and the execution proceeding has been stated in the said application that this application along with CRP IO 211 of 2025 be listed on 25/5/2026.
Right.
Yeah, just a-
Item 4,
May I please, Your Lord? My lord, in this matter, except respondent number 2, 3, 4, and 8, these are expired, my lord, and other service is complete, my lord. So we have collected the particulars of the legal affairs of these deceased respondents, my lord. So some time may be allowed to us to file necessary application for substituting the legal affairs of respondent. As per office note dated 18/5/2026, my lord, service is complete except this deceased respondent.
And you have filed an application for substitution.
We have to file my substitution because we have not yet collected the exact date of death of this respondent, so some time may be allowed to us. Open January.
But that's not what we have got for the petitioner. And Mr. H.R. Ahmed and counsel agreeing for respondent number 1 in bracket A to G is 1 E bracket G. As per office note dated 18/5/2026, notice is duly served. On respondent numbers 11 to 34. However, none appears on call to the said respondent. Next. As per office note dated 7/1/2026, it is served on response number 5, 6, 7, 9, and 10. Next, However, it's order dated 21/1/2026, respondent numbers 2, 3, 4, and 8 have expired. Next, counsel for the for the joint police. Time to file, to take necessary steps. Right. Proceedings of title execution case number 27 of 2014 have been paid. The petitioner through the input within the extended time. During which orders goes for the interest of the petitioners may be passed. Next, this from due date after 2 weeks. But take steps, otherwise execution petitions are there, we will proceed. Execution petitions will not be stayed.
My lord, there is interim order, my lord. Interim order is there.
The order past is stands extended, but we are putting you to notice that if steps are not taken, adverse orders may be passed.
Yes.
Item 5 with item 6.
May I please, Lordship? Lordship, this matter pertains to execution of a expert degree on the specific performance of contract, Lordship. Lordship, kindly page 26, order, Lordship, a title short. Page 26, Lordship.
Page number,
Page 26, 26, Lordship. Order in the title short, Lordship. Lordship, what? May I read, Lordship?
yes,
In view of the above discussion and decision reached in the following point of determination.
you
Lordship,
read it, what do you want to say?
Here, Lordship, my contention is that, Lordship, here the Honorable learned trial court below, while passing the decree, has given 3 months' time to deposit the balance consideration amount. And the decree holder, Lordship, failed to pay that balance consideration amount within the stipulated time fixed by the learned court below, Lordship, which is a violation of section 28 of Specific Relief Act 1963, Lordship. And after getting the decree, Lordship, the decree holder put the decree for execution, Lordship, under order 21 rule 11, the petition, Lordship, will find that page is 31. Page 31, Lordship. I will take my Lordship to page 33, page 34 and page 36 of the petition. Here, Lordship,
Then what did you do?
here, although they have failed to deposit the balance consideration amount within the period fixed by the learned trial court below, they have straight away filed this execution petition without making any prayer or without any
What
application.
did you do?
Huh?
What did you do? On receipt of the notice in the execution petition, what did you do?
I filed objection under section 47, Lordship. And that Lordship will find at page 37. This came to be dismissed by this order, Lordship, page 41.
Rightly so. How will an objection to execution be maintainable?
Lordship, after which, Lordship, I also filed an appeal under order 913 against the ex parte order, Lordship. Against the ex parte order, I also filed an appeal under order 913, Lordship, and the CRPIO and the appeal in a composite order by this honorable court, I disposed of.
Dismissed, not dismissed.
Yes, Lordship. Lordship will find page 44. Against the order of the executing court and the ex parte decree of the learned trial court below.
Where is the impugn order dated 1/3/2023? Page 96. Impugn order.
May I read, Lordship?
So he had deposited the money. Yes.
Here,
And was the court accepts it? The fact that there was in the decree, there was a time limit for 3 months to make deposit. Not coming the way.
Lordship, another thing I would like to draw Lordship attention at page 74, Lordship. Kindly at page 74. While the execution proceeding was going on, Lordship, the judgment debtor died. And the decree holder, without filing a petition under section 50 CPC, they have directly filed this substitution petition, which is not maintainable as per order 22 rule 12, Lordship. Page 74. They have not filed any petition under section 50 after expiry of the judgment debtor. So the executing court, without having prayer from the decree holder under section 50, don't have jurisdiction to entertain this to proceed with this execution proceeding, Lordship. Because
That is not under
section
challenge.
50,
This 2020, 27 to 2020 order is not under challenge. Is that impugned in this revision? No.
this is not under challenge. My contention, Lordship, the decree holder.
Contention, you see, contention, you know everything.
No, decree
You may have
holder,
100 things to say, but
Lordship,
if you're not there to listen to 100 statements you are wanting to make.
that is,
Challenge
Lordship,
is-
that is, I admit, that is not under challenge, but the decree holder ought to have filed a petition under section 50 to have jurisdiction by the
hear.
court.
Can't hear.
Lordship,
Things which are not under challenge can't be heard.
Lordship, decree holder has not filed any petition under section 50.
We told you, we are not hearing those things. I am hard of hearing. Things which are not material for this application cannot be heard.
My Lordship, my respectful submission is that in a specific performance of contract in a specific relief act, Lordship, the decree passed by the landed trial court below is a conditional or preliminary decree. If the condition is not fulfilled by the decree holder, then the decree itself dismisses automatically. The suit lying before
Any
the
authority on the point? Any authority on the point?
Lordship, I am citation. Just 2 weeks back, Honorable Apex Court has given this judgment, Lordship.
Citation to PSC.
Relevant portion, Lordship, may kindly at page 17, paragraph 35.
Citation to citation.
Mary, Lordship.
Yes.
In view of the ratio laid down in so and so that the suit for a specific performance of contract stands automatically dismissed no sooner than the condition contemplated under the decree is not complied with. Coupled with the fact that there is no mandatory requirement for moving an application for rescinding a contract in terms of section 28 of the Act in view of Rem Jivan Supra, we are of the opinion that the plaintiff respondent having not only failed to deposit the balance sale consideration within the time stipulated under the decree, but also having failed to move any application for extension of time within the time permitted disentitled himself from executing the decree. There is neither automatic extension of time nor condonation of delay in making the deposit. The decree ceases to exist due to non-compliance and becomes inexecutable. Here in the instant case, Lordship, the decree holder never filed any application seeking for extension of time. And there is no explanation as to how they have deposited after so many years of lapse of time.
Yes. But I won't.
My submission before Lordship Miller. First matter regarding mandatory of this revision petition. It has been filed under section under Article 227 of the Constitution of India. And since the matter it is a civil case and the proper court is the civil court and without any restraint or any alternative remedy, they cannot approach under Article 227 of the Constitution of India. Secondly, he has suppressed the fact, more particularly, when other legal hires they given no objection regarding the execution of sale deed. And the Ladet court, the executing court passed the order to deposit the amount as per their no objection. Out of 9 legal heirs, he is the only son who objected to the execution of the decree. That is I have within the that is the petition in the execution petition filed on 8/7/2024 by the legal heirs. Only the petitioner and except the petitioner, all other legal heirs has given no objection. Paragraph 2. In the above noted case, and accordingly, if the honorable court execute the registration of the sale deed on behalf of the decree holder, then the above noted judgment debtors have no any objection. And in pursuance of that application, the executing court passed the order on 8/7/2024. Directing the decree holder, legal heirs of the decree holder to deposit the amount and to obtain sale permission. And in absence of the petitioner, the executing court was directed to the solicitor of the court to execute the decree. And the plea of section 28 of the specific act.
Got this on record by filing an affidavit? This document, have you bought on record by filing affidavit?
No, no.
Without affidavit, you're not taking into cognizance anything.
Then I may be allowed some time to obtain this.
We'll give you 3 days time, we'll take it up on Monday.
Yes,
If the execution cases are pending, we have to get
yes,
it out, get it out of the.
maybe if it should be about the coin, maybe it will below the coin. That's why it should be into other people. It is clear, it should be spoken on. Legal heirs are all legal heirs. They are giving out the stated. No. What a coin.
This is one of the petition. Be a Kayun, then conflict for the. We are asking for all the respondents.
Well, except yes, with 1, 2, and 3.
We are telling for
All the respondents, item number 5.
for the respondents. What is this? JD number B1, 1 to 3. Somebody died. Who died?
In other cases, in item number 6. In item number 6,
is wrong. Somebody died in the execution proceeding and they were substituted.
Lordship.
Yes, yes.
Original judgment debtor, right, and after,
Who was the original judgment debtor?
Bachu Sheikh,
Bachu Sheikh.
Lordship.
And who was the legal representative?
Lordship will find page 32, legal representative.
52. These are legal representative of the judgment debtor.
Judgment debtor.
Then how your CRT be maintainable? You have imputed all the three respondents. Whereas substitution is made of 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13 people.
30 people, Lordship, judgment debtor, legal heirs.
That's not the, you see, I can understand that much.
Lordship.
Have you understood the question put by us?
Lordship.
What is the question?
The other,
What is the court query? You see, you are making submissions without understanding the court query. We'll dismiss your application for non-gender.
here, Lordship, I beg to make submission, Lordship, in this regard, Lordship. Here I have come before your Lordship in my independent capacity, not as a legal heir, Lordship. Because I have purchased the same suit land and against who is title appeal is pending before the landed court below.
Parties in the execution proceeding are not to be brought on record when you sue in an independent capacity. Correct?
Lordship.
Good. This is called ease of doing business. I would have nothing more to say in the order. Right. So a Mr. Learned Counsel for the petitioner and Mr. D.A. Kayum appearing for the respondents. Next para. It appears from the documents appended on record that the in the proceedings of PX number 2 of 2018, Mohammed Nurul Huda Sarkar, who was the plaintiff petitioner, had died. And according plaintiff degree holder had died. And by order dated 22/1/2021, the degree holder was substituted by three legal representatives who were numbered as A, B, and C. Stop. The judgment, the sole defendant, judgment debtor, namely Bachu Sheikh, BACCHU Sheikh SK, alias Basir, BASIR, Basir Sheikh, had expired. And he was substituted by eleven legal representatives who were numbered as A2, H, and I1, I2, and I3, respectively. Mr. Power in the constitution of this application filed under Article 227 of the Constitution of India, only the legal representatives of the decree holder have been arrayed as respondents. So the legal representatives of the decree judgment debtors have not been included. Accordingly, the present application is hit by the principles of non-joinder of necessary, proper and necessary parties, as the representatives of the judgment debtor are also essential for adjudication of this matter. Next, the learned counsel for the petitioner submitted that the petitioner has filed this application in his individual capacity and not as the legal representatives of the substituted judgment debtors. The said submission would not dilute the non-joinder of necessary parties, for which is found to be fatal. So accordingly, this revision application stands dismissed on account of non-joinder of necessary parties.
Lordship,
Without the matter being heard on merit.
I pardon my lordship. Lordship, can you can liberty to file amending petition.
We asked you, but you gave that statement. We told you you have done ease of
I'm
business.
sorry, Lordship.
No. Please always be cautious. When you give us the handle, we are ready to take it. So this order shall not preclude the petitioners from approaching the court again in an appropriate manner, is so advised.
Obliged.
Your document, Mr. Kaim. Next matter. No, one matter. This next matter is not being heard. Yes. Next item, 6.
My lord, I am appearing on item 6 here. Here, I am for the third party, my lord. One petition under Order 21, Rule 97 was submitted before the trial court in the execution proceeding. And it is dismissed, holding that this time is not maintainable. Liberty has been given to file a separate suit. And Order 21, Rule 97, this petition filed under Order Rule
Order 21 Rule 97 may be treated as regular suit, Your Lord.
How have you laid your claim?
My Lord, part of the decretal land, Your Lordship, we are possessing by the right of inheritance, Your Lord.
Right of inheritance and flowing from whom?
My Lord,
That right of inheritance you have got from whom?
from Kassu Sheikh.
From
Kassu Sheikh. Kassu Sheikh and Basu Sheikh are the two brothers. They are two brothers are the owner and patatar of the entire land.
what is the document to show that?
My Lord. So on page 14, Your Lordship.
14.
Total land was 5 bigha something, my lord. 5 bigha 4 kathar something. And the same was allotted among them, divided equally. Co-part was,
You're only showing us a chita. Chita doesn't mean anything. Entering the chita doesn't create title.
my lord,
Neither is a document which is admissible under section 41 of the Assam Land and Revenue Regulation. Chita is always a draft.
and accordingly we are possessing, my lord.
No, that's okay. You are possessing
And
it.
without making
Okay.
us as party in this proceeding, they obtain some decree, my lord.
No, please tell us, how do you get title? What is the document of title according to you? Your name is not there in the Jamabandi. Obviously, it is not, because otherwise you would have produced that. So if your name is not in the Jamabandi,
My lord.
when due diligence is exercised, Chita would never be seen. Chita is not a document which is required to be inspected for due diligence for purchasing a property.
My lord, during the course of my lord mediation, my lord, this Baksu Sheikh illegally mutated his name in respect of the entire land.
You have to take some of the fight there.
But
Just there is another forum to take that fight. Your name is not there. So you are in position, continue to be in position. Let the let the decree be executed. What is wrong in that?
But my lord, honorable trial court ought to have, my lord, adopt a procedure as like as a suit, my lord, regular suit. The my lord, trial court has not.
You don't have title. You don't have a title. Not a 90 you say you are in position. How you show your position? You say that you are in position.
My lord,
How were you in position? There are two ways to possess it. One is by constructing house. The other is just like immovable property. You just keep it close to your chest. How did you possess that property?
Page 39,
Yes, we're there.
page 39, my lord. Here,
No, we understand, but how do you possess that property? 2 bigha, 4 kata, 16.5 lacha.
my lord.
What is the document? In addition to chitta to show that you are in possession.
Trial court ought to have called for a report from the concerned circle officer
Not
regarding
trial.
the possession.
Not required. You make a statement,
My lord, I have stated, my lord.
correct? So you will have, the burden is on you to show, you stand in the foot of a plaintiff. You tried as a suit, but you become the plaintiff. It is your duty to get it.
My lord, my humble submission before your lordship, my lord, let the trial court be directed to process the petition filed under section 21 rule 97 and to allow us to adduce evidence, your lordship.
No. Independent right you have not been able to show. Perhaps the title has not been shown away. In every exhibition, hundreds of people will come and say that I have a right, I have possession, I am there, I am there. The exhibition can't be thwarted like that. You don't assert your right against the owners of the land. You want to fight against the decree holder. This chitta is an entry of which year? Page number?
Page 14, your lordship.
1/4.
1/4. Particular at page 15, 16, your lordship.
1/4. This chitta entry is of 2012.
Right.
And you say in the Gauhati the name was mutated. It was done when?
My father's name is Kasu Sheikh, my lord. Here,
That's okay.
It
We are
is
not disputing
mentioned.
that. We are just asking you a question that this is a chitta entry of 2012. When was the Gauhati corrected in the name of the judgment debtor? So, if
my
it's a
lord,
suit,
in the year 1973, my lord. The
70
ceiling allotment was, my lord, allotted to two brothers, Kasu Sheikh and Basu Sheikh, your lordship.
73.
73. Ceiling allotment. Here it is written, your lordship. My lord, a ceiling 100 public,
73.
my
Ceiling
lord,
allotment book number so and so.
my lord.
It is
In the name of Kasu Sheikh and Basu Sheikh.
and so when the
Divided.
corrections were made in the Gauhati,
Later, my lord, in the Zamabandi, this Basu Sheikh illegally mutated his name.
but when it was done, date, is it available? suit for possession based on title is how many years? Even if 65 is there, 12 years. So the right to is extinguished.
My lord, may I submit one more thing, my lord? As per rule 103, your lordship, order passed under order 21, rule 97 may be treated as decree, and against that order, my lord, and maybe liberty may be given to
There was no
approach the
decree passed.
appellate
Your
court,
case was dismissed
my lord,
and you were given liberty to go approach the suit, file a suit.
appellate court,
No,
My lord.
to file a suit.
separate suit.
So there is no decree. There is no judgment in your favor to create a decree.
My lord, may I
What is a
read,
decree?
may I read to 103?
You start reading from section 2. What is a decree? Read section 2. Definition of decree. Let me also refresh my memory.
Sorry, Your Lordship. But order passed under order
But
21,
just read that,
Right.
not very difficult task
Right.
to read.
orders to be treated as decree. Where any application has been adjudicated
No.
Upon-
You see, you are reading 21-103. I start reading from section 2.
section 2, Your Lordship.
Section 2, definition of degree.
Yes. Section 2, subsection 2, Your Lordship. Decree means the formal expression of an adjudication which, so far as regards the court expressing it, conclusively determines the rights of the parties with regard to all or any of the matters in controversy in the suit, may be either preliminary or final. It shall be deemed to include the rejection of a plaint and the determination of any question within section 144, but shall not include any adjudication from which an appeal lies, as an appeal from an order, any order of dismissal for default.
So
From my limited understanding, my lord, order passed under order 21, rule 97, my lord, may be treated as decree, and I may,
now you must have changed your opinion by now after reading section 2 too.
and
If you have not, then you have to pass orders. We'll take a short break and come back.
Seven.
May I please, Your Lordship?
Where do you have the mediation then? How are you proposing to do it?
Lordship, sorry, Lordship.
Both of you want to settle the matter outside the court?
Yes, Lordship, as per my instruction, Lordship, my client is ready.
Lordship, on the last question, wanted to know whether there was any sort of mediation earlier at any point of time. To that, I have instruction that there was just no mediation.
You see, why we are apprehensive is of the fact that these are family disputes. And mediation is always desirable. And experience shows that parties take time for mediation or settlement, the settlement, and then after 5 or 6 months, they will come and say that there is no settlement. So it takes away prime time of both the parties. So therefore we wanted to know if there is no mediation, then either at Silchar or at Gauhati, you have a mediation done through a trained mediator. You carry on your talks of compromise between the parties, but also avail mediation. Correct? Suggest a date, both of you.
Whether Gauhati or Silchar, Lordship. Both
Depends
parties
on
residing
you.
at
You
Silchar,
see, if the parties are both at
residing at Silchar.
Silchar,
Silchar.
then I think Silchar would be more preferable.
Yes,
It can be
yes.
done in the
Yes.
mediation center at the district judiciary.
Not sure.
Either first week of June or second week of June, Lordship. Today is 21.
Today is 21.
Lordship.
So
Today is
have it
20.
on 4th of June?
Today is 20.
4th of June,
4th of June,
you have sufficient time then?
Lordship.
Yes? Mr. F. Bormier and counsel for the petitioner, as well as Mr. M. H. Laskar and counsel for the respondent. Next paragraph. This matter arises out of matrimonial proceedings and therefore by order dated 11/5/2026, the court had put a query as to whether any attempt has been made for mediation between the parties. Full stop. Next paragraph. The learned counsel for the parties has submitted that we have received telephonic instructions and as per instructions received, no mediation has been done between the parties. Next paragraph. No, parties, full stop. However, it is submitted that the intra-party negotiations are intra-party talks of compromise is going on. Next paragraph. As the dispute between the parties are matrimonial, in the considered opinion of the court, attempt of mediation would be more desirable without affecting the intra-party settlement process. Next paragraph. Accordingly, the court is inclined to direct the parties, i.e. the petitioner and the respondent, to appear before the mediation center in the district judiciary at Kachar, Silchar. To stop. The principal judge, family court, Kachar, Silchar, will facilitate a mediation proceeding between the parties by on 4/6/2026 by engaging a trained mediator to mediate the dispute, all the dispute between the parties. Full stop. The parties and or their respective learned counsel shall produce a copy of this order before the learned principal judge, family court, Kachar, Silchar, just to arrange for a mediation in the dispute between the parties. But at least one day prior to the date fixed for mediation, is whenever this, the done court to arrange for mediation between the parties to a trained mediator. Stop. The mediator shall have as many sittings as may be desired to settle all the dispute between the parties and to submit a report to the learned principal judge, family court, Kachar teacher within 8/7/2026. And the learned principal judge, family court, Kachar teacher is requested to forward a scanned copy of the report of the learned mediator to the registry of this court to be tagged with the report. Next one. The learned counsel for the petitioner and the respondent is also requested to send an honorable copy of this order to the respective parties. Next one. List on 15/7/2026. One time for mediation, then a report to the family court will send it here.
Second. In the meantime, family proceedings day.
Which one?
Family court proceedings proceed. Next date is 29/5.
Next one.
This
In order to facilitate mediation, the further proceedings of FC within bracket civil bracket post case number 194 of 2018. Pending before the learned principal judge, family court, Kachar Silchar, shall remain state at the next date of this day.
The instant division petition will be listed thereafter also.
It will come on the date. You have already fixed a date
Lordship.
for this thing.
Obliged.
Item 16.
Item 16 for motion.
I have currently passed for this matter 4 times. Because the conducting council is on left me, so you inform me, my way.
Seventeen. Yes.
In order, your lordship will find from page 132.
32.
Page 132.
Why you need a commission with the nature of prayer you are making? Why you need a commission?
My lord, under the provisions of order 26 to 9, my lord, I made a prayer that
Why?
a commissioner be appointed by the court below.
Why?
For,
Now you have district level rates of every property.
no, that is there, my lord.
then why you need,
So far as ascertaining the present market value, for that I had made.
that is impossible. That is impossible, a commissioner cannot do it, because even the deputy commissioner, when it comes to land acquisition,
Well,
determines the market value from the sale deeds which are registered in the sub-registry.
well. Like here, my lord, in so far as the position is concerned, the sale deed is not yet executed. The sale deed has not been executed. That is to be executed through court process in terms of Order 21 Rule 34 CPC at the instance of the decree holder. Now, our contention in the execution proceeding after having received summons and appeal is only to the limited extent that we,
Now, who procured the valuation report, which is there at, referred to at page 99 on
the judgment debtor, the
who is the
judgment
judgment debtor?
the judgment debtor, the petitioners number, the petitioners over here, who are the judgment debtors number 2 and 3.
So you produce a report and then you come to court and you can say, please appoint a commissioner.
No, what happened, my lord? So far this report was concerned, that we were allowed to be produced in terms of an order at page 98 by the learned court below. Your lordship has seen that order.
No, we have not seen. I just read here and there and jump to
My
conclusion.
lord, page 98, your lordship kindly takes up first of all.
98.
98, this is
First
the
of all, where is the decree passed?
decree. Yes. Your lordship will kindly see the judgment in decree start from page 51 and the decree, the specific decree that has been passed, your lordship will kindly take up page
Now-
69.
Now, please tell us, in this decree which has been passed,
My lord.
is on the basis of an agreement for sale.
Yes, 37, 2016.
In agreement for sale,
Ma'am.
there is already a amount fixed.
Yes. 1
Now,
crore 7 lakh.
Is there anything in the agreement which says that that apart from the agreement,
My lord.
the market value prevailing would be the sale consideration?
My lord, admittedly, there is nothing in the agreement.
So you want to expand the scope of a decree?
My lord, what I am saying is, my slippery grounds cannot be denied. But the only fact remains. Till the time of filing of the written statement, in our written statement, we took two pieces. One is regarding the valuation of the property, and we took a stand that so far as the amount incorporated in the agreement is concerned, that is in the form of a written agreement, but over and above the written agreement, there was an oral agreement by way of which there was another amount that was agreed upon. My lord, I understand that this is something that will be
No, not that.
beyond
I'm not
pleadings.
that. What comes to the mind
My lord,
is not what you are saying.
My lord.
What comes to my mind is 102 of the
yes,
Evidence Act.
yes, my lord.
Can an evidence be
Absolutely.
contrary to the written document be tendered?
Now, my lord, my lord, problem, that is something which we could have substantiated. There is more difficulty on my way. Subsequently, after filing of the written statement, we did not contest the suit. That is the bigger difficulty. Which that's why I straight away said, my lord, I am on slippery grounds. But your lordship will kindly appreciate these were facts, two aspects we took up in our written statement. One is the existence of an arbitration clause in the agreement itself, and the other being the value of the property, which though incorporated in the agreement, but as per a valuation report which was prior in point of time, was 2 crores and odd, more than 2 crores in the year 2014.
I will give a very horrible example. You will excuse me for giving that horrible
Okay.
example. You see, this is a pen of ₹10. I'm in urgent requirement of money and I went to sell it. And I am being offered in public auction ₹1. Correct. Now, does this value of this pen of ₹10 carry any meaning when I am making a distress sale? No. And is there any law which prohibits any person from selling it undervalued? The requirement is that even if you sell it undervalued, you'll have to pay stamp duty as per the DLR, district level, that.
Prevalent rate.
Correct. So irrespective of whatever is the amount, if the deputy commissioner or the registrar or the deputy commissioner in the form of registrar or the sub-registrar finds that this property ought to have been valued at a higher amount, you have to pay just the
Stamp duty.
Stamp duty.
Yes, fine.
But that does not give any right to a seller to say that on market value, give it to us. That is the proposition laid down by Supreme Court only in one case. You will find that is a case of Salman. Just like a Salman was
Salman Khushi.
not Salman Rushdie. Pakistan. Salman Rushdie.
Salman Rushdie, yes.
Salman Rushdie. In that case, you will find long back, Supreme Court in 1990s, it has held. There was a property in that Lutyens area, which he was owning. And there was an agreement for sale, and this was not paid. So after about 20 years of litigation, the Supreme Court says that now this property value is higher, and therefore you pay a higher amount to this author. And that Supreme Court used 142. The agreement between the parties cannot be overridden by this court in 227.
I understand. I understand. Only prayer that I made before the learned court below was being a court of equity as well, my lord. What I prayed is that I am
Court of equity, civil court.
my lord, 2014-15 SCC 529, my lord, specifically on this point. If for a while, my lord, just
Yes.
one character. Paragraph 30. My lord, I may be terribly wrong in my interpretation over this, but
No,
my
no,
lord
that's
will
fine.
allow me just an opportunity in regard to items, in regard
Beauty
to.
of practice in law is that even if you are wrong, you are always right.
My lord, paragraph,
That is the beauty of practice in law.
I am obliged. Paragraph 30, my lord.
Just a moment. You see, the answer is inherent in in this order. Para 30, you are saying.
Yes, ma'am.
Yes. Para 30 does not say about court being a court of equity.
My lord, only in regard to balancing of equity, what it says is in a suit for specific performance of contract.
No, because here it says that under 28 it retains control.
Yes.
And therefore this is our authority on the point that decree passed in a suit for specific performance of contract is made equivalent to preliminary degree. And the original order in which this was held is that the next para 31,
My lord,
Hungerford investment, Haridas Mundra.
my lord, my lord,
This is the case where this proposition was laid down.
my lord, my lord.
that even if a decree is passed, it is for the nature of a preliminary decree. The reason for that is totally different. It says that in a preliminary decree, because there is a draft order to be, a draft sale need to be made, to be examined by the court, and thereafter sent for execution.
Yes.
So therefore, it says for that purpose, it's amount to a preliminary decree.
My lord, I am losing out, or not losing out, my lord. I am in fact, I have already given away the property. The property actually was, in fact, parted off with long back, when there was an initiation by the concerned bank under SARFAESI. And in that, my lord, eventually my counterpart came as a savior at that point of time. Now, he agreed to purchase this property, and because of which, my lord, the loan dispute was settled with the bank. But the only problem then was the amount that was incorporated in the agreement for sale. That amount, even at that point of time, was half the amount of the property. In 2000,
Just old time traveling train. When you give any other person to give a space to sit, he will then not only sit, he will take over the entire berth.
I understand. I am obliged.
Unless you travel with Mr. Satar.
Yes, sir will obviously give me my.
If he travels, then that doesn't happen. Yes, Mr. Satar, we allow this application.
My lord, after hearing me, if your lordship pleases to allow, your lordship can. I don't have. My lord, first of all, I will take your lordship to page number 51, lecture 4.
It is always pleasing to do wrong things. It is always pleasing to do wrong things.
My lord, 3 persons were the judgment debtors. Out of that, only one is before your lordship.
No, two are there.
No, only one.
No, two are there before your lordship.
No. I'm taking your lordship to page number 51, wherein the judgment debtors are 3. Now, my lord, this IO is filed by 2 persons who were the partners of judgment debtor number 1, DP Motors. Now, my lord, from the judgment itself, your lordship, at para number 12, which is at page number 59, my lord. At the time of preemptory hearing, the plaintiff reduced his evidence as PW1 and examined 2 other witnesses and exhibited as many as 16 documents. On the other hand, the defendants, after filing their written statement, abstained from appearing before the court and neither cross-examined the plaintiff's witness nor adduced evidence in their support, So, my lord, after that, when the judgment is passed and the decree is made therein, they don't have any right to save and accept under section 47. Under section 47, my lord. Accordingly, the petition under section 47 was filed, wherein, my lord, the judgment debtors have pleaded that there was a writ petition by them against the bank. My lord, kindly see page number 88, my lord. Page number 88. Page number 88, my lord, first page will show that Mr. Parnab Datta, he filed a writ petition against State Bank of India, Deputy General Manager, the Chief General Manager, and Branch Manager then deputy commissioner, then the circle officer, and then the superintendent of police, my lord. There, my lord, the present decree holder was not the party. So whether the property at that stage of time was of rupees 2 crores or less than that is immaterial so far the decree holder is concerned, my lord, because I was not made party to this place. Now, my lord, there was an order passed to have some valuation report from the government valuer. That valuer's report
In this order.
it is there, my lord. It is there, my lord. If your lordship pleases to see para page number 89, in the entry in the,
We get it. This is surface application.
This
Yes.
is against e-auction sale.
Huh?
This writ petition was against an e-auction sale notice.
Yeah.
Understand.
in the entry in the e-auction of the property scheduled on 27/8/2014 is stated until the reserve price is reconsidered by the bank by taking into account the PW's building valuation dated 14/8/2014. Annexure D, and the land valuation made by the government approved valuer on 18/8/2014. Now, my lord, the operative part of this order passed on 22/8/2014 by Honorable Justice Rishikesh Roy was that in the interim, the e-auction of the property scheduled on 27/8/2014 is stayed until the reserve price is reconsidered by the bank. By taking into account the PW's building valuation dated 14/8/2014. Now, my lord,
Yes, please continue.
yes, my lord, I would like that your lordship should also peruse page number 92.
92.
The reconsideration of the value in between the bank and that of the judgment debtor was considered to be, my lord, I am reading that, my lord, it was by Honorable Justice A.M. Buzarg, Mr. D. Chakravarti.
8820.
Yes, my lord, 88. And now thereafter, my lord, the person has agreed to sell it to me at rupees 1 crore and 7 lakhs. More than that of 88.2. I can take your lordship to my sale agreement dated 37/2016.
What is the amount?
1 crore 7 lakhs, my lord.
What is the date of your agreement?
Date of the agreement is, my lord, 37/2016. And it is a registered agreement.
30?
In date of the agreement, my lord, 30/7/2016. In between, there was negotiations between the bank and that of the judgment debtors. Now, my lord, if your lordship pleases to peruse page number 40.
Page 92 is,
Page 40 is the registered deed
No,
of
this,
agreement, my lord. It starts from
so this page 92 is order dated.
92, my lord, in fact, is the order dated,
22/2017.
yes.
Yes, okay.
So when the bank and the judgment debtors, present judgment debtors came to a negotiation about 88.20, then they felt it better that if the property is sold at the rate of 1 crore 7 lakhs, at least they will be fetching a good handsome amount. And that's why they agreed to sell it to at rupees 1 crore and 7 lakhs, my lord. So where there is question of any equity into this, when there was a contract in between the judgment debtor, and your lordship has rightly given the example of the pen. Pen is of 10 rupees, but at distress I am selling it at rupees 1. Maybe a distress sale, but I won't agree to that. It is a in distress sale because of the reason that when the bank and the loanee has agreed to 88.20, my lord, and I am paying, I mean the prospective purchaser is paying 1 crore 7 lakhs. it cannot be said to be a distress sale. It cannot be said to be a distress sale. And my lord, thereafter, my learned friend has filed an application under Order 26 Rule 9, which is rightly rejected, because there is no question of any Order 6.
I forgot, execution, what is the proceeding, what is the provision of commission?
Commission for, my lord, there are many commissions.
No, in execution, what is the provision for commission?
For commission, for this one, my lord, Order 26 itself.
No. For finding out the land and all, there is another provision in the PPC for commission.
It starts from, my lord, Order 26 Rule, in fact, procedure for commissioners, report by the commissioner 10 appraisal for investigation. My lord, commission to make local investigation, Order 26 Rule 9. And before that, my lord, before I should conclude before your lordship, I want to show your lordship page number 39, last paragraph. My lord, it is not that the judgment debtors were not aware when they were entering into the agreement with me. My lord, whereas loan outstanding liabilities in respect of both the loan accounts were fully settled between the State Bank of India, Angarkhoa branch, primary, and migrated to State Bank of India, SAMB, Bhamni Maidan, Gauhati, Shri Parnab Datta, for a full and final consideration of rupees 1 crore 7 lakhs, rupees 1 crore 7 lakhs only, in the National Lok Adalat held in the Honorable Debts Recovery Tribunal, Gauhati, on 8 August 2015. Then, my lord, at the next page on paragraph. Whereas on being approached by the first parties, they are the first party persons, the second party had agreed to pay the entire settled amount of rupees 1 crore 7 lakhs to the bank, and out of which the second party had so far paid an amount of rupees 63 lakhs 30,000 only up to 31/12/2015, from 16/8/2015, and in consideration of which the first party have agreed to transfer the title in respect of the mortgaged property described in the schedule to the second party after the said property is released by the bank in favor of the first party on full liquidation. So when the amount was paid, full liquidation was made, and even, my lord, the sale deed was also prepared, then they became reluctant to sign it. So it is not that, my lord, they were not aware of, and it cannot be said to be a distress sale. There is no question of coming of any equity, my lord, according to my respectful submission before the lord.
But Mr. T. Chakravarti, the counsel for the petitioner, and Mr. T. Chakravarti, the counsel for the petitioner, as well as the petitioners, and Mr. A. Satal, and the counsel for the respondent. Next part. Filing this application under Article 227 of the Constitution of India. Petitioner has assailed, petitioners have assailed the appeal order dated 20/4/2026, passed by the learned civil judge within bracket senior division, bracket Lakhimpur, North Lakhimpur, by which petition number 88 of the 26 is that petition?
Page 120.
And it 17/1/2026. Filed under order 26/9 CPC in connection with TX number 1 of 2024 for appointing commissioner to ascertain the market value of the declared property was rejected. Is a sale. Sale, so that's okay. Next one. The learned counsel for the petitioner, by referring to the documents appended to this application, has submitted that pursuant to directions of the Court of Learned, executing court, that I, civil judge within bracket senior division, Lakhimpur, valuation report dated 18/8/2014, prepared by a government approved valuer, was filed wherein the land was valued at rupees 1,14,78,407, and the valuation of the building was made at rupees 1,05,00,000,000, and accordingly the valuation of the declared property was assessed at rupees 2,19,78,407. Full stop. the said valuation report was objected to by the respondent decree holder. Accordingly, on the ground that the agreement for sale, where the property was valued at rupees 1,07,00,000, is stated to be much lower than the market value of the property, the petitioner filed petition number 88 of the 26 on 17/1/2026 for appointment of a commissioner for ascertaining the market value of the property. It is projected that as the value of the decreed property was about rupees 2 crore more than 10 years ago, the current value of the property would be much higher. Accordingly, it is submitted that the learned executing court, and mechanically rejected the said petition number 88 of the 26. On the ground that the executing court in under section 47 of the CPC cannot examine the validity of the order and decree passed by the court unless the order of the court is itself without jurisdiction. And accordingly, it was held that the valuation of the suit property cannot be allowed to be challenged at this stage as the said valuation has not affected the decree or made it null and void. And accordingly, the petition was rejected. Full stop. Next, referring to the grounds of challenge, the learned counsel for the petitioner has submitted that the period for ascertaining the market value of the property or could not have been rejected, and that the decision of the learned court below was perverse. More so, when the valuation of the property conducted in the year 2014 was rendered obsolete, from our current valuation of the property was required. By referring to the case of Rajinder R. Jajinder Kumar versus Kuldeep Singh and others, KULDEEP, Kuldeep Singh and others, within bracket 2014, bracket was 15 SCC 529. It has submitted that he said decision is an authority on the point that the suit for specific performance of contract does not come to an end on passing of the decree, and the court which had passed the decree retains control over the decree, and accordingly it is stated that the court had the power to assess the valuation of the property. Anything else you wanted to say? Accordingly, prayer is made to interfere with the instant order. Next, per contract, the learned counsel for the respondent has submitted that in the documents appended to this application, it would be evident that the judgment debtors had judgment debtors of the respondents were had availed loan from the State Bank of India and on their default from a
The option notice was issued, my lord.
surface process were issued.
E-auction sale notice was issued against which we came. Against the e-auction sale notice, we came
No, e-auction
under surface.
Under the surface here.
Under surface.
Yes,
Yes,
No.
sir.
And surface action was initiated, and against the e-auction notice, where the liability of the petitioner was of the petitioners were assessed at rupees 1,54, 13, 879.37, the reserve price of the property was only 88.20 lakh. And accordingly, on the ground that the government approved valuer had determined the market value of the property at rupees 2,19,78,407, the petitioner number 1 had approached this court by filing WBC 4066 of 2014.
Agreed to 88.20, madam. That is page number 92, madam.
No, that is different. That is, we are reading at page 89 now.
Yes.
And accordingly, this court by interim order dated 22/8/2014 had state the e-auction till reconsideration of the reserve price by the bank. To stop. By referring to the order dated 20 February 2017, passed by this court in the said WBC 4066 of 2014, it has been submitted that that notwithstanding the reserve price of the e-auction of the property was 88.20 lakh. But as the matter was amicably resolved between the parties, the petitioner number one did not pursue the writ petition, and accordingly the writ petition was closed as not pressed. Full stop. It is submitted that thereafter though the reserve price of the property was assessed at rupees 88,20,000, the petitioner and the other partner of the the petitioners. The petitioners are petitioner number 1 and 2. They are the partners of DP.
Yes, ma'am.
The petitioners approached the respondent, who agreed to purchase the property at value of rupees 1,07,00,000 by agreement for sale dated 30/7/2016. So it is submitted that the said value was an agreed sale consideration, and only thereafter, the petitioners would settle the loan amount and entered into the said agreement for sale of land and building. So accordingly, it is submitted that it is not a case where the petitioners were not aware of their dues payable to the bank, the SARFAESI action taken by the bank, and accordingly entered into an agreement for sale with the respondent for the security asset at a consideration of rupees 1,07,00,000. However, after liquidation of the loan, the petitioners did not execute the sale deed, which compelled the petitioners, the respondent, to file a suit, which was ultimately, which though contested by the petitioners by filing written statement, was not contested and abandoned. And the contest was abandoned. And the ex parte decree came to be passed. Next one. Consider the submissions as well as consider the case of Rajendra Kumar Supra, cited by the learned counsel for the respondent. It is not in dispute that this court, in its order dated 22/8/2014, passed in WPC 4066 of 2014, had referred to the assessment of market value of the property at rupees 2,19,78,407. And with the eyes open and on being conscious of the said order dated 22/8/2014, the petitioners entered into the agreement for sale of land and building, which was executed and registered on 30/7/2016. To stop. It is also admitted that the petitioners did not contest the suit by filing by producing evidence or by cross-examining the witnesses of the respondents, plaintiffs, respondent plaintiff. And therefore decree came to be passed. To stop. The decision of the Supreme Court of India in the case of Rajendra Kumar cannot be read to mean. No, we say like this. The learned counsel for the petitioner, by relying on the case of Rajendra Kumar within bracket Supra, had referred to paragraph 30 of the said judgment. To stop. On a perusal of the said judgment and specifically paragraph 30 thereof, the said judgment cannot be read to mean that the court which had passed the decree for specific performance would retain the would retain the jurisdiction in the jurisdiction and control over the decree, so much so that the decretal that the decree could be modified to enhance the sale consideration by the executing court. To stop. In this case, the decree was passed by the Court of Civil Judge within bracket Senior Division, Lakhimpur at North Lakhimpur. And the same court, while undertaking an execution petition, cannot be said to be the court which had passed the decree. To stop, an executing court would have a different role than a court which is passing a decree. To stop. This this can be culled out from the provisions of section 28 of the Specific Relief Act, which is couched in a language which clarifies this. Full stop. The provision of section 28 of the Specific Relief Act is quoted below. Full stop. From the provision of subsection 1 of section 28 of the CPC, of the Specific Relief Act, it is very clear that if the purchaser fails to pay the purchase money which the court had ordered him to pay, the vendor may apply in the same suit in which the decree is made to have the contract rescinded.
That's right.
Full stop. Therefore, in a suit for specific performance of contract, if the decree is sought to be rescinded, the application has to be made in the suit and not in the execution proceedings. Full stop. Therefore, though the two courts are same, one which passed the decree and the one which is executing, but both are cloaked in a different jurisdiction. Full stop. Therefore, the court does not find any merit in the challenge to the Peon order dated 20 April 2026, passed while rejecting petition number 88 of 2020, or 88 of 26. Full stop. The learned executive court is found to be correct in its appreciation that in an application under section 47 of the CPC, the executing court cannot examine the validity of the judgment and decree full stop. In this case, the parties, despite knowing the valuation which is reflected in the order dated 22/8/2014 in WBC 4066 of 2014, with full knowledge and full knowledge and so with full knowledge of the effect, full knowledge of the same, entered into a otherwise lawful and valid agreement for the sale of land and building, and had given a valuation which was agreed to, the executing court had rightly not examined the issue of valuation in an execution proceedings. Accordingly, the challenge to the order dated 20 April 2026, passed in TX number 1 of 2024 by the learned civil judge within bracket senior division of Lakhimpur, fails, and accordingly this application stands dismissed at the motion stage without issuance of notice on the respondent. Next panel. the parties are left to bear their own cost. There's a caveat, discharge that caveat. Mr. Satar appears for the caveat.
Obliged.
Yes,
As your lordship has not given the cost, I am not praying for that also.
no, you have a right.
As your lordship has not given the cost, I am not praying for that also.
No, you have a right, but you have to go.
No, I am not going to go. I am not
But,
going to go, my lord.
but thanks for this judgment. Well, in fact, I was taking the help of Mr. Podar here to understand few things of execution. This will help. This,
My lord, that is only with regard to section 28 of the Specific Relief Act,
no,
where the order is passed and not complied by the decree holder. Only then.
that is okay, but we were discussing, last 2 days, we were discussing to understand few things, nuances of the execution.
My lord.
As I am taking this bench after quite some time.
My lord, he was not only the learned judge, but a learned advocate also. Oblige your lordship. Keep your flag.
Item 18.
In this case, sending the order dated 27/4/2026, passed in the title suit as well as the Ms. J case.
Where is your petition and where is the order?
Well, the order is at page 149
And the petition?
for adjournment. That, my lord, is 148.
This petition was filed at what stage?
Well, the matter was fixed for hearing upon the application for rejection of claim. That was petition number 471/2025.
But you find a lot of adjournment petitions.
My lord, I've brought down the
For
copy entire.
For 2 years, you are taking adjournments. I think that is right.
My lord, the adjournment was sought by the petitioner in respect of the petition number 471 of the 25.
Who is the petitioner?
The respondent number 1 and 2. They filed an application for rejection of claim. I was the plaintiff OP. And my lord, it allows me to, I will take this and go to the order sheet in a very. My lord, Annexure 3, page 30.
Because you see, you are telling us that 149 is the impugn order.
My lord.
By this order, you were heard.
No, my lord. I was not there.
But the counsel for the defendant.
Defendant, sir. Respondent number 1 and 2. They filed an application for rejection of them. I filed a petition, my lord. The counsel for the plaintiff has filed a petition bearing number 724/26 and annexed the copy of the medical document, sir.
You see, these orders which you have produced,
My lord.
always it is the plaintiff who is taking time.
My lord, this is the order, my lord, if I may take this.
Plaintiff side submitted petition, plaintiff side submitted petition.
My lord, the order sheet, if I may take this on board to the order sheet. In respect of the petition which has been filed. My lord, the order sheet, if my lord takes up the order sheet which I have filed, after discovery and inspection, my lord, on 107, if my lord comes to page 107. It will be clarified, my lord. We have not delayed the matter, neither sought any adjournment to delay the matter. My lord, 107, on that day, my lord, we filed an application under order 6, rule 17 of the CPC. My lord, next page, my lord. On 17/2/2025, the defendant number 1 and 2, my lord, filed a petition for rejection of claim, that is 471/25. Thereafter, my lord, the matter was fixed for objection hearing on that petition, and the amendment application was taken up first. Amendment application was taken up first and was disposed of, my lord, by order dated 14/8/2025, which my lord will please to find it at page 114.
No, but before that, at page 109 and 53, you took adjournment. 27/3, you took adjournment.
My lord, that is 2025.
Whatever be this application, this, you see, this suit is of 2024.
My lord, then we filed our objection, and accordingly the matter was fixed. But prior to-
On 17/5, you file objection.
on 17/5/25. But my lord, prior in point of time was my application for amendment of claim. I filed my application for amendment of claim on 27/1/25. That was prior in point of time. So, my lord, when I filed my petition, ultimately the amendment application was disposed of by the order dated 14/8/25, which my lord is 114. And next date, my lord, was fixed on 11/9/25 for amendment claim. However, my lord, the original plaintiff suffered from illness and ultimately, my lord, the original plaintiff passed away on 19/9/25. So in view of such circumstances, there was an assignment, my lord, and accordingly, in view of assignment, we filed a petition for regarding to assignment, my lord. And that assignment petition was taken up by the Honorable Trial Court and ultimately disposed of by order dated 8/1/26, which is at page 131. So, my lord, after disposal of this assignment petition, the next date was fixed on 7/2/26 for filing substitution petition and hearing on petition number 471, that is page 136, my lord. And the order dated 7/2/26, my lord. Both parties filed petition on page 137. Now, my lord, on page 138, order dated 23/2/26. Today, this instant suit is fixed for substitution / hearing on petition number such and such. Plaintiff has submitted the amended plaint of substitution as per order date such and such. Furnished copy. The counsel of defendant number 5 has filed a petition bearing number such and such, and the counsel of defendant number 1 and 2 has filed a petition such and such. And again, it was allowed for last time. And next page, my lord, page 139, order date 7/3/26. Contesting parties are represented by the learned counsels. Today was posted for hearing on petition number such and such by the petitioner / defendant for rejection of the plaint. Peruse case record. It transpires from the case record that the petitioner had filed petition bearing number such and such, and since then he has been availing numerous opportunity to submit hearing on the petition, but failed till date. Today again, the petitioner has filed petition bearing number such and such, seeking time for adjournment.
with cost.
Yes, so it was filed by them, my lord. And next date was fixed on 25/3, and 25/3, my lord, on page 141, the presiding officer was on leave. And on 27/4, my lord, I have enclosed the medical documents due to sudden onset of some medical issue. Though, my lord, the tickets were booked, I have enclosed the medical documents, my lord. Page 144, my lord, if peruses. It's a report, my lord. Due to ill health of my wife, my lord, I could not visit on 27/4. And even the tickets were booked, my lord, which is at page 147.
You are the petitioner.
I am the, yes, ma'am.
So you took time on 7/3.
No, 7/3, they took time, my lord. I am not the petitioner. My lord, the order dated 7/3 shows,
Here it says paragraph 4, today again, the petitioner has filed petition number so and so taking time.
my lord, para 2.
Para
Today it
4.
was posted for hearing on petition filed
4.
under order 7 rule 11 by the petitioner / defendant.
Para 4.
Yes, my lord. It transfers from the case of petitioner has filed. So they have been referred as petitioner because they are a petitioner in order 7 rule 11.
Yes.
So thereafter, my lord, on 27/4, it was booked due to sudden medical emergency, my lord. As I have enclosed the document, I could not visit, but even the tickets were booked, my lord, page 147.
Yes.
My lord, just want to submit further, my lord. One more thing, my lord. So in title suit, my lord, the order was passed as rejecting my right to argue in respect of an application under order 7 rule 11. My lord, if my lord comes to page 189, in the injunction application was dismissed, my lord. The injunction application was dismissed, my lord. It says that contesting parties are represented. Counsel for the petitioner has filed petition bearing such and such. in the petition, he has prayed for adjournment, heard such and such. The petitioner has failed to submit the substitution petition within the period of limitation. The right to sue of the petitioner is extinguished upon death of the original petitioner in connection of this case. In view of expiry of statutory period of limitation, accordingly, the prayer in the petition is rejected and the instant petition is dismissed. My lord, the assignment petition was allowed on 8/1/26. So once the application for assignment was allowed, my lord, by order dated 8/1/26, which is at page 131, my lord. How could the learned trial court dismiss my petition for want of substitution petition? So we have impugned both this order, my lord.
This Mijje case is what?
This is injunction application.
Injunction petition, if it dismissed, you'll have to file an appeal.
My lord, since considering the nature of the order, I pray before the Supreme Court to take up this matter under Article 227, because this order, my lord, on 189, page 189, my lord, it says that it's completely erroneous, my lord. Because the trial court itself allowed my application for assignment. So once the application for assignment is allowed, my lord, how can my injunction application be dismissed on the ground that non-filing of substitution petition? When the person concerned are already on record. So this amounts to exercising jurisdiction to my humble and respectful submission, my lord, not vested in it.
Yes, Mr. Parvez.
Your Lordship, page 189, this order is passed in J 4 of 2026. So,
Okay, case number, my lord.
J is a 4 of 2024, pending before the court. And this is the certified copy. This is one step. And your Lordship may see the conduct of the parties. Here they had earlier filed surface application before the debt recovery tribunal. And that surface application was rejected by the DRT. Subsequently, this title suit was filed.
No, you see, we are not hearing the order 7 rule, orders, what do you call, 7 rule 11 application. We are looking at the order. The conduct is only to show whether the adjournment taken was bona fide. The ground is that the wife of the advocate was ill and medical certificate was produced and he could not be present for hearing.
Lordship may fix a date for hearing. Because I personally know that he was having problem on that date.
So there's nothing on nothing in this, if the wife of the petitioner was ill.
Yes, my lord. He was hospitalized on that date.
If he was ill, then the order would be was not correct. The party should not suffer for the advocate's default. If his wife is ill,
Yes, my lord.
then we interfere with this order. So where is the medical certificate of your wife? You said you annexed with your petition. Where is that?
My lord, ultimately she went for undergone surgery, page 142 at Patna. So I've enclosed the discharge certificate on 1/5/26.
Police certificate.
And the urgent one, my lord, page 144 is the ultrasound report. That is of 25/4/26.
Given opportunity.
Just I pray a short date may be fixed before the hearing,
For the
before the court, trial court.
Mr. A.K. Right on counsel for the petitioner. also had to say for West London, standing also for the respondent. Number 1 and 2. Next, in view of the order that is proposed to be passed. Issues of notice on respondent numbers 3, 4, and 5. Dispensed with as they are not found in contesting petition number 471 of 2025, in which the impugn order dated 27/4/2026 was passed. Or in the proceedings of Ministry case number 4 of 2026.
It would be 24. I think it's incorrectly numbered. 4/2024. My lord comes to page 187, the correct case number.
4 of 2024. Next up. Filing this application under Article 227 of the Constitution of India for the petitioner. The petitioner, who is the plaintiff in Statute number 3 of 2024, pending before the Court of Learned Civil Judge within bracket Senior Division, bracket was Lakhimpur, North Lakhimpur, has assailed the order dated 27/4/2026, passed in PS 3 of 2024, by which petition number 471 of 2025 was rejected. The petitioner has also assailed the order dated 27/4/2026, passed in Ministry case number 4 of 2024, by which injunction application was dismissed. Injunction application under order 39 rules 1 and 2 was dismissed. This is injunction application.
Injunction.
Next part. The learned counsel for the petitioner has submitted that petition number 471 of 2025 is an application filed by the defendants in the suit, defendants number 1 and 2 in the suit, praying for rejection of the claim. And the proceedings of Mijay case number 4 of 2024 was an application for injunction under order 39 with 1 and 2. So it is submitted that during the pendency of the suit, who had died,
The original plaintiff, my lord.
the original plaintiff had died, which is reflected in the order dated 19/9/2025, and in the meanwhile, there was an assignment of the property, and accordingly, the Court of Learned Civil Judge within bracket Senior Division, bracket was Lakhimpur, North Lakhimpur, by its order dated 8/1/2026.
8/1/26.
8-1, that's why I said so. 8-1/2026. Allowed the prayer for assignment under order 22-10 of the CPC. And the new owner of the property was substituted as the plaintiff. What is his name?
Page 131 is the order.
Rajiv Ahmed.
Rajiv Ahmed.
Where is the name?
Rajiv Ahmed.
No, in the order, where is that name?
But the petition has been allowed, oh, my, page 132. The, second paragraph, the name is reflected.
I filed the assignment
Assignment in
petition.
favor of Rajiv Ahmed was allowed. On (27/4/2026), the but if the assignment is allowed and you are the plaintiff, in your petition at page 148, you still reflect Jahanara Hazarika. Why?
But the first title might be mistaken. It should have been Rajiv Ahmed.
Petition was 7/4/26, no? 7/4/26. Paying for adjournment on the ground of ill health of his, of the wife of the learned conducting counsel. So in support of the said petition, medical documents were also enclosed. So the learned counsel for the petitioner has posited that the wife of, that his wife was diagnosed of acute cholecystitis, CHOLECYSTITIS, and adenomyosis, ADENOMYOMATOSIS, page 144. As per the ultrasonography report, dated 25/4/2026, and she had undergone a surgery
Page 142, on 1/5.
on 1/5/2026 for acute cholecystitis. At a hospital, the private hospital at Patna. To stop. You've seen that by another order passed. First of all, however, by order date 27/4/2026, the prayer for adjournment was rejected and the learned counsel for the respondent numbers 1 and 2 were heard. Was heard on petition number 471 of 2025. But by another order passed on 27/4/2026 in initial case number 4 of 2026, as there was no substitution in the suit, the said initial case number 4 of 2026 was dispatched. Next part. Although the learned counsel for the respondent numbers 1 and 2 has vehemently objected to their made in his application, considering the fact that the wife of the counsel for the petitioner was ill and had undergone surgery few days four days after on 1/5/2026, i.e. 4 days after 27/4/2026, court is of the considered opinion that the learned counsel for the petitioner has had justifiable reasons for making prayer for adjournment. Accordingly, the said order suffers from non-consideration of the materials available on the court and before the order dated 27/4/2026 private to be completed. Next one. Insofar as order dated 27/4/2026 in initial case number 4 of 2024 is concerned, although the dismissal of the initial case of an application for injunction is an appealable order, but in this case, the petitioner has been able to demonstrate that by an order dated 8/1/2026, assignment under order 22/10 of the CPC was allowed in favor of Rajiv Ahmed. This amounts to substitution on the devolvement of the property to the assignee. And therefore, there is no requirement of a substitution in order 22/3 of the CPC. So therefore, the said order is also found to be frivolous and perhaps casting ignorance of the effect of order dated 8/1/2026. So therefore, the court has no reason to relegate the petitioner to an appeal, as the order dated 27/4/2026 is found to be frivolous, contrary to the order dated 8/1/2026, allowing acceptance assignment. Therefore, the said order dated 27/4/2026 passed in initial case number 4 of 2024 is also found to be without jurisdiction. Accordingly, the same is interpreted with. It will be mentioned that the certificate copy of the order dated 27/4/2026. This case is wrongly referred to as 04 of 2026 instead of 04 of 2024. Next paragraph. It is clarified that the interference to the order dated 27/4/2026 in VJ case number 4 of 2024 has been interpreted with under the unique facts of the set of this case, and therefore this order shall not be a precedent in any for any other case for entertaining an application under challenge to orders passed in the injunction application under Article 227 of the Constitution of India. Next part is the petitioner and the respondent, the number 1 and 2 are represented. Both parties directed here before the learned civil judge within the senior division, that it was Lakhimpur from Lakhimpur on June
June 1st
Friday.
June 1st week.
My lord,
Fifth is Friday.
can it be on sixth, my lord? Sixth, Saturday,
Saturday.
Saturday.
Yes, Principal, yes. Sixth,
Sixth of May.
6/6/2026, and the petitioners, the petitioner are producing certificate copy of the order. Wait for the orders to pass by the said limit. Just a moment. Okay. First, the petition pending. Say, certificate pending. Okay.
Well, the plebs.
Question no orders focused. Item 19.
Item 19.
Before the presentation of the petitioner, for parliamentary proceeding request and adjourn today. Please come on. Yes. Can you speak?
Timing item 12.
Wait, let's see.
Yes.
In this case, I am sending the order dated 4/12/2024, where injunction has been given. Page number is started from page number 60, 50, under a land grabbing case, and Mijay case has been filed. The order has been passed in Mijay case.
Where is the application? VJ case application, where is that?
Mijay case application, Lordship, page number 43 onwards, Lordship. 43, Lordship.
Yes. I just forgot, which page you said is the petition?
Petition number, it is started from 43, Lordship.
43. Yes.
Yes, Lordship. Here, Lordship, this page number 43, Lordship,
Yes.
he is claiming the 2 acres of land under Dag number 42, 46 and Patta number 252 belongs to her. Lordship, there is no dispute in my land and her land because already partition is there, demarcation is there. In the original land giving suit, Lordship, therefore, report was called for, Lordship. Let whether there is a land giving or any land has been belongs to the petitioner, Lordship, which she is claiming. And the Lordship says report, Lordship, if such a peruse, Lordship page 41 and 42, Lordship. This given by the circle officer, Lordship, to the court. Page number 41. May I read, Lordship?
Where is, this petition, where is the schedule of land?
Schedule of land is, Lordship, 2 acres of land, Lordship, under page number 17, Lordship, schedule of land. page number 17, Schedule C, Lordship.
But you see, you are showing us page 42. In 42, in the name of Mohammad Hanan Haq Chaudhry,
Lordship.
the land of Abdul Hanan Chaudhry is 1 bigha 4 kata 3 lesha.
Lordship.
And the dark number and pata numbers are the dark number 417
Yes,
and pata number is 243.
yes, Lordship.
In this schedule here at page 53,
Lordship.
that's not the land.
Paper and land, Lordship. Lordship, so in this report, Lordship clearly stated that I have not enforced any land, Lordship, as a land giver, Lordship. In the first line, Lordship, আবেদনকাৰীয়ে গোচৰ তথা আবেদনত উল্লেখ কৰা তফচিল নথিৰ লগত সৰজীৱনত ঠিকেই থকাটো সত্য যদি বলপূৰ্বকভাৱে প্ৰতিপক্ষই দখল কৰা সন্দৰ্ভত তথ্য নাই। That is, Lordship, their land, they are existing, and my land, I am existing, Lordship.
Okay.
But landed court below, Lordship says that no construction. In my land, Lordship, if I can't construct, Lordship, and landed Supreme Court, Lordship, Apex Court also says that to land giving, there must be some satisfaction, Lordship. Land giver cannot be alleged land giver.
But it should be mounted on counsel for the petitioner. Petitioner is the respondent. The petitioners. The petitioners of the respondents in the proceedings of special within bracket LG case number 8 of 2024. Which is filed under the Assam Land Grabbing Prohibition Act from 2010. Just what they said, suit was filed. Next one, the suit was filed by the respondent alleging that the present petitioners had grabbed for land. Full stop. Next one, in connection with the said case, a separate application was filed under order 39-1 and 2, read with section 151 CTC. Led with section 8 within bracket 2 of the Assam Land Grabbing Prohibition Act, 2010, paying for ad interim injunction, and the learned additional session judge number 2, Nagaon, which is the jurisdictional court for proceedings under the Land Grabbing Act, by an order dated 4/12/2024, passed in ministry case number 15 of 2024, in special LG case number 8 of 2024, granted identity injunction, restraining the petitioners from dispossessing the respondent from the Schedule B land, from carrying out a new FCC construction on land described in Schedule C, excavating any soil from the Schedule B and C land, digging any fishery on etc. semicolon, taking any judicial electricity energy for the grabbed sea land, semicolon, starting and carrying out any business in the RCC room illegally constructed over the Schedule C land, semicolon, and changing the nature, feature, and character and topography of the Schedule C land. Agreed by the said order, the present application has been filed in Article 227 of the Constitution of India. The appellate tribunal is not constituted. Appellate tribunal is not constituted. Appellate tribunal is there or not?
Appellate is there. Tribunal is there.
Appellate tribunal is there.
There.
Then why you have not filed an appeal?
Appellate tribunal, they are not there. We have before. In fact, appellate tribunal is not there. Let's be. Tribunal is there.
The Knowledge Council for the petitioners has submitted that the appellate tribunal no, the special court to hear appeal under section 13 has not been constituted under the Assam Land Grabbing within bracket Prohibition bracket close Act of 2010. Accordingly, this application has been filed. You should notice, including notice on the prayer for interim relief, returnable on due date after 4 weeks. The appellate shall take, the petitioner shall take steps within 2 days for service of notice on the respondent by speed post EAD. Next, list on so and so. We should notice on the prayer for interim relief.
Achieve interim order.
No. Your order was passed in
Yes,
2012.
let's see. Only on one observation, then make that interim order be considered.
You have already issued notice.
Let's see. Come,
52.
Supplementary item 52.
Make procedural option. I've come against the application rejecting my order rejecting the Order 7 Rule 11. Before that, may I just give the facts?
Where is the petition?
Petition under Order 7 Rule 11 is at page 113. Madam. Lordship, give me a minute, my lord. May I just give the background, my lord? The wife of the plaintiff, my lord, she was working as a circle officer. At that point in time, I was the deputy commissioner of the district. There was some proceeding against her, my lord. She was placed under suspension. Then, my lord, the office peon had gone to her house to serve an order. There it is the allegation of the peon that the husband, that is the plaintiff, my lord, he misbehaved or something happened, my lord. He filed a complaint before me, my lord. I filed a complaint before the registrar of the university where he was working, my lord. He was working as a professor of the Bhattadev University. Against that, an inquiry was conducted, my lord. Now,
Just a moment. 4 names have come. You are?
I was the deputy commissioner at that point in time, deputy commissioner of Nalbari district.
Yes.
The wife of the plaintiff, my lord, she was working as the circle officer.
Yes.
There was some proceeding against her. She was placed under suspension. Then one office peon had gone to serve
a document to her house.
Hmm.
Official document, my lord. The husband, that is the plaintiff, my lord, it is the allegation that he misbehaved. The peon as well as the workers, the employees association filed the complaint before me. I wrote a letter to the registrar.
And the husband alleges that the peon misbehaved.
No, my
Filed
lord.
the complaint before you.
Peon alleges that the husband misbehaves.
Oh, that's right.
The plaintiff misbehaves.
Just. Yes, complaint is filed before you.
The complaint is filed. It's a small complaint, but a complaint is filed before me. I file a complaint, madam. I don't file a complaint exactly, madam. I issue a letter to the registrar of the university, where the plaintiff, which is the was working, madam.
Page 61.
Page 61 is that letter, madam.
The husband works there.
There. So basically, I am writing a letter to the person who has lawful authority over the plaintiff. Now, thereafter, madam, some newspaper publications were made. There is also a communication from me to the principal secretary regarding the conduct of the wife of the plaintiff, madam. Now, a legal notice is sent to me, alleging that I have issued a letter. Then,
I am sparring.
madam,
Where the notice cannot be legal notice.
but
It can always be an advocate's notice.
yes, it's a advocate. I'm sorry, madam. Peter's notice. A Peter's notice is sent to me,
No, just,
madam.
I don't know.
And then the suit is instituted. Now, in the Peter's notice, what is alleged is that I have wrongfully issued that letter to the registrar of the university. It is nowhere stated in the Peter's notice that subsequent press, there has been publications in the newspapers which are defamatory in nature, and my lord, no relief is claimed. It also does not say it is under 80 CPC. Now, I file an application under Order 7, Rule 11, seeking rejection of the plaint, entirely on the ground that no proper notice under Section 80 CPC has been issued to me. If your lordship comes to page 117, madam, that is part of my application under Order 7. Lordship has got it.
Yes.
That all the communications as relied upon in the plaint being communications made by the applicant defendant number 1 in her official capacity as the district commissioner, the plaint is liable to be rejected forthwith for non-compliance of Section 80. Even assuming, though not admitting, that the annexure G legal notice annexed to the plaint to be a notice under Section 80 of the CPC, the applicant states that the said annexure G does not set out any cause of action for defamation for which the plaint has been filed, and the relief which the plaintiff has claimed in the plaint are not set out with sufficient particularity. The said notice does not set out with exactitude who, in what manner, before whom, and when the plaintiff alleged defamation took place, tarnishing the prestige of the plaintiff in the minds of the right-thinking members of the society. So this is the plea taken by me, and the learned trial court, my lord, in the impugned order, has held that the pleader's notice is substantial compliance of sections 80.
Where is the notice?
Notice. Notice it at page 71. 72 and 73 are the same pages, my lord, wrongly annexed. 71, 72, and 74.
71.
1. If the pleader's notice, my lord, it does not say that it is under 80 CPC. It narrates the entire facts, and at page 74.
You are appealing for the respondent?
Yes, ma'am.
Yes, what do you have to say?
My lord, here in this case, my lord, the present proceeding, my lord, the order, my lord, which was passed, my lord, in the input order, my lord, which was passed in this case, my lord, that is interlocutory in nature, my lord. And my lord, against that order, my lord, the section 115 of the CPC, my lord, cannot be applied, my lord. It is, I have the question on maintainability of this petition, my lord.
My lord, had it been decided in my favor,
That is easily rejected. The reason is that if it would have disposed of the
Exactly.
proceeding,
Yes, my lord.
that is the language,
Yes, my lord.
then if
Now-
order 7 to 11 is allowed, will it not dispose of the suit?
My lord.
Then
Here, another thing is that, my lord, that is my preliminary objection also, my lord. Here, my lord, if a lordship goes to the inquiry report, my lord,
you must raise an appropriate preliminary objection.
my
It exposes your what you call your legal appreciation of the provision itself. Does it help you?
no, my lord.
Will a lawyer, I don't find any lawyer will, of any credence will like to praise a provision knowing it to be wrong. You destroy your credibility as a lawyer.
My lord, that
I'm
provision
sorry to
was
say,
wrong
it pains
understanding.
me because I come from the same place where you are standing.
My lord,
You
provision,
shouldn't
that was
lose
my
your
wrong
credibility on
understanding.
that
Yes,
account.
yes, my lord.
That just because you have an opportunity, you raise all such plea which is unnecessary.
My lord. Here,
Destroys your credibility.
my lord. Here, in this case, what happened, my lord? The incident, my lord, the
You
my
forget
lord,
the incident. You are on the order.
my lord. Here in this,
Is this notice at page 71 in compliance with order, section 80?
my lord,
What is the requirement of the section 80?
my lord, it clearly shows the cause of accident, my lord, date of occurrence, my lord, everything was, my lord, in the
Please tell us,
legal notice.
we read section 80, tell us what is the requirement.
Notice, my lord. Where is, my lord?
Don't read, just tell us. This is something we have read. You just tell us what are the ingredients if you read section 80.
My lord. Here, my lord, what happened, my lord? May submit, my lord. I can clarify, my lord. I have made the party, my lord, the vulnerability as a private respondent, my lord, not in his official capacity, my lord. I did not admit him as official capacity, my lord. Because, my lord,
That's all. You did not argue more.
my lord,
That's all.
my lord, just I want to submit, my lord.
Please tell us. The letter to the university was written in what capacity? Private capacity?
My lord, he had written as a district commissioner, but he, my lord, that letter, my lord, that university is beyond his admission jurisdiction, my lord. That is separate district, my lord. That is Bodali district, an autonomous university, my lord.
Who has said that the deputy commissioner cannot write to any person outside his district? Where is the law?
My lord,
Under
yes, my lord.
executive rules of business, where is that law?
It was, my lord, jurisdiction is there, my lord.
Mr. Hawk, you need not argue anything more. The, the court says that this is, it amounts to section 80 notice.
Exactly. Right.
Once the court says so, this is not an appeal where you can raise a cross objection.
Right.
You must now tell us whether this notice was under section 80 or not. Your notice was under section 80 or not? Just a simple question. When you have made the answer, we could have gathered, we could have presumed something, but you are not presuming because you are present. Tell us, according to you, the notice is under 80 or not? If you have issued under the private capacity, it cannot be a notice under 80.
Yes.
Correct. This order is set aside for no reason other than that. And please mind it, it will destroy your entire case because we will say that this is done in a private capacity. As for you, you are the plaintiff. Then you take the responsibility of what you have said.
Yes.
That's why we told you, don't make submissions which destroys your credibility.
May feel for some time.
No. You made your submissions, that is good enough. You made submissions on a point which astute lawyer should not have argued. Had Dr. Hussain Dekal and senior counsel assisted by Mr. B. Chaudhary, Learned Counsel for the petitioner. Also heard Mr. S. Fox Leonard appearing for the respondent creator. By filing this application under section 115 CPC, the petitioner who is the defendant
Number one.
in statute suit number 2 of 2025 has assailed the order dated
1/4/2026.
passed by the Learned Civil Judge within bracket Senior Division bracket Nalbari in on an application bearing petition number 827/25,
Miss J case 53, madam.
which was registered as VJ case number 53 of 2025, being an application under order 7 Rule 11, read with order 6 Rule 16 of the CPC. Next. The Learned Senior Counsel for the petitioner projects that at the relevant point of time, the petitioner was acting in his official capacity as the Deputy Commissioner of Nalbari District. And in his establishment, the wife of the plaintiff, respondent as plaintiff, was working as then posted as a circle officer. So, in connection with an official work, the office beyond from the establishment of the Deputy Commissioner of Nalbari had gone to the residence of the circle officer, and the respondent, who is the husband of the said circle office, the then circle officer. Later on, the office peon came and made a complaint before the petitioner alleging that the husband of the said circle officer, that is the respondent plaintiff, had misbehaved with him. So accordingly, the petitioner, in his capacity as the deputy commissioner, Nalbari, had written to the registrar of Bhattadev University, Nalbari, Bojali, where the respondent plaintiff was serving.
Actually, my lord, not misbehave, here the recorded video. It is while delivering the letter, recorded video. But subsequently, that was culminated to harassment and unruly behavior.
The next para, the learned counsel for the respondent has submitted that the said office peons, while serving notice on the respondent plaintiff, made a video and accordingly agreed by the video from the respondent plaintiff alleged that the alleged that there was an harassment. Next, be that as it may, that this court is not examining the nature of complaint made by the peon, and therefore no comments are made thereon. Next paragraph. It could suffice to mention that the respondent plaintiff then issued an advocate's notice dated 30/8/2024, addressed the petitioner as deputy commissioner in her name, referring her to the deputy as deputy commissioner, and alleged alleged that the acts of the petitioner was amounted to resorting to falsehood, and there was embarrassment and harassment to the respondent petitioner, respondent plaintiff, and accordingly, alleging ulterior motive, the petitioner was put to notice to respond within 15 days as to why legal action, both criminal and civil, should not be initiated for defaming him and defaming the respondent plaintiff. Next one, on the said ground, and on projecting that the suit as well as the injunction application was filed without service of any notice under section 80 CPC, the petitioner filed an application in PS number 2 of 2025, whereby just say like this. Thereafter, the respondent, by filing PS number 2 of 2025, What is the relief sought for?
The relief sought for is compensation of 3 crores. Somewhere it is said 2 crores, but in the plaint it is ultimately 3 crores.
That's not for damages and compensation amounting to rupees 3 crores.
3 crores.
To stop.
2 crores, madam, I'm sorry. 2 crores.
So 50.
Page 58, 2 crores.
So I'll have to rise, and dictate the order, the application is being allowed. Matter would be the order 6 to, the order 7 to 11, application would be revised. Past orders in the chamber, there is a meeting right now at
Madam.
4:30.
Madam, in the second item also it is the same there. It is, I have,
Take it up some other day. 53, yeah, 53.
day after tomorrow, madam.
Dictated in the chambers, it will be completed today, tomorrow morning it will be uploaded.
Right, all right.
Not tomorrow morning, by the time it uploads, it will be almost the second half. At the lunch period, we'll be able to upload it.
The other matter is day after tomorrow, madam.
Second 53.
53.
You have to know. And any other request for upgrading, please tell it to the court master.
Lordship, item number 22 is also reached.
20.
I have 22. I have come from Silchar for the hearing. So in
Item
8:50
22.
Item number 22. Okay.
You have to take some other day. Admission matters.
Yes.
You have to take some other day. Take a date of your convenience from the court master. And if there are cases where interim orders are to be extended, please tell the court master the orders would be extended. There are any interim orders to be passed.
আপুনি আকৌ আহিব তেনেকে আপুনি দি দুটা ফটো হৈ যাব ঠিক আছে থেংক ইউ নাহে যদি আপোনাৰ ঈদৰ গ'ল 29 তাৰিখে 3 তাৰিখৰ আগতে এই এটা কাম কৰিব দিব হ'ল ডাক্তৰ Friday kita for stop the Monday before you wait for the our like Kisuri এইটো কিমান আইটেম চাবস্ক্রাইব 53 no Favorit এই 52 আইটেমটো যে আপুনি শেয়াৰ কৰিব নালাগে হা এইটো চেম্বাৰ নহবও পাৰে হা এইটো আপুনি কৰিব নালাগে আপুনি 53 আইটেমটো আজি হল 20 তাৰিখ নহয় আপুনি 22 তাৰিখ 22/5 ন এই দুটা সম্ভৱ তাৰপাছত নাই বাকিবোৰ লেফট ওভাৰ নহয় 44 আপুনি হেৰি লিখক 22 লিখক 22 আইটেম ডাবল 2 ডাবল 2 হা 10th of June 10/6 ডাবল আইটেম ডাবল 2 আৰু ডেটটো হ'ল 10 June আৰু আইটেম 16 16 ফুল ডেটটো হ'ল 29/5 আৰু দুটা আইটেম আছে 43 আৰু 44 মই ডেট দুটা দি দিছো চাই পেলাই মই ডেট দুটা কেলেণ্ডাৰ চাই কৈ আছো দেই 43 44 25/5 আপুনি হেৰি কৰক 16 22 43 44 মই এইটো চাই লৈছো দেই আইটেম 8 টো মানে কি জানে এইটো অৰ্ডাৰ পাছ কৰিব মই চাই লৈছো আৰু কওক আয়ে মানে কেইবাটাও আছে নহয় গোটেইকেইটা ডিছপ'জ কৰি গায়ে গোটেইকেইটা ডিছপ'জ কৰক আৰু CRP টো 22/6 হয় ঠিক আছে 30 70 18 টো হ'ল নহয় এইটো হ'ল আৰু এই আইটেম 555 যে 555ৰ আইটো ডিছপ'জ এতিয়া 16 22 43 44 গোটেইকেইটা ওলালে ন সম্পৰ্কক দুটা প্ৰতীকক দুটা দি দিম নাই সম্পৰ্ক আৰু প্ৰতীককে দি 53 টো সম্পৰ্কে পাইছে এইটো আপুনি অকলে দি আহক নহয় এইটো দি আহক কথা আছে দি আহক আগতে এই কামটো কৰি লওঁ লোকৰ কামটো ফাইলটো ক'ব এই দুটা প্ৰতীকৰ এই তিনিটা এতিয়া আপুনি আহি পেলাই লেফ্ট অভাৰটো মাতি দিব মানে পটককে এইকেইটা দি আহকচোন নাই সেই প্লাছ মাইনাছত নাযাব দেই আগতে ফাইল গণ্ডগোল হৈছে ন আকৌ পুৰণি বেয়া দিনলৈ কিয় ঘূৰিছে আপুনি ফাইল কেইটা এবাৰ মোক মাতি দিব আপুনি নাই সেইবিলাক নিয়ম আমি জানো কিয় এইবিলাকত খেলি মেলি লাগিছে বেঞ্চ চব ধৰা পৰি যায় কিবা কাৰণত বেঞ্চৰ পৰা এটা ফাইল আহা যদি সেই দুটা সম্পৰ্ক নহবা আগতে আমাৰ অভিজ্ঞতা ভাল নহয় ন